So good evening, everyone, and thank you for joining us. My name is Darla Pompilio. I'm with Your Tasks Our Time, Senior Mood Management and Downsizing. Our goal for tonight's presentation is to provide financial and legal strategies for proactively managing transitions. Our organization is Senior Services Network of Southeastern PA. We started Senior Services Network because most people are not sure where to begin when navigating resources and often don't know what resources are needed until something happens. Our goal is to be one place where seniors, caregivers, and their families can have access to service providers in the southeastern Pennsylvania area. Tonight, I would like to introduce our speakers. So one of our speakers is out sick this evening, but her partner, her partner, Mary Slack, her partner, Mary Slack, is the co-founder with Dawn Wright of Day-to-Day Financial Management. So Mary is stepping in for Dawn this evening. So I'm going to go ahead and read Dawn's bio because, as I said, they're partners and they did create this presentation together. So Dawn has more than 20 years of insurance experience, most of that time spent with AIG. During her time managing sales and operations for regional product groups in New York and Philadelphia, Dawn developed a broad range of knowledge with annuities, medical insurance, budgeting, and financial management. These skills assisted her with becoming a daily money manager. Mary's background is in accounting and Oracle Financial Systems consulting with the federal government. Mary and Dawn enjoy getting to know their clients and understanding what is most important to them so that they can help them stay in control of their financial life. And our second speaker this evening is Jessica Sauer, Esquire of Sauer Law Firm, LLC. Jessica has been practicing law for over 14 years and focuses her practice on estate planning, estate administration, and court matters such as guardianships, conservatorships, and adoptions. Jessica is a co-chair of the Estate Planning and Probate Committee of the Mercer County Bar Association. Jessica is passionate about helping her clients prepare for the future by aligning the estate plan to meet their wishes and needs. So before our speakers begin, I want to invite those of you who have questions for the panelists to please add those questions to the chat. At the completion of the presentations, we will go to your questions.
Thank you, Darla.
You're welcome.
Thank you. All right. Thank you, Darla, again, and thank you to our audience for attending. As Darla mentioned, I will discuss financial strategies for managing life's transitions. As our family members age, we may notice that they may need a little extra help with things like the household chores, transportation to places, and their daily household financial tasks. Those family members may not want you to know that they are having difficulties. They may try to hide the problem. It is important to be observant and ready to step in. For this webinar, we are focusing on providing assistance with financial tasks and discussing where to begin. I'll provide a few suggestions on how to begin a conversation and the financial information you may need to be able to locate from your family members, and along with tips for keeping these documents safe and organized. And to keep it simple, I'm going to be referencing more this conversation as if you're the adult child trying to have a conversation with the parent. But this can apply to any family member, and it still can apply to your parent if they feel they are ready to broach finances with their children. Because this conversation is so important, Senior Services Network of SEPA's November 17th webinar provides more details on how to hold a productive family meeting. So as adult children, it's always hard to know when to start a family conversation with those family members who may be in need, in particular our parents, about finances. It's a tough conversation, right? But it is one of the most important conversations you can have. As a daily money manager, I talk to clients all the time about this. Of course, I knew that it may not be as easy a conversation if I had to have the conversation with my own parents, because at that point I become their child versus their hired daily money manager. Your parents may not be ready to have the conversation, so you have to be prepared for that. And mainly, a lot of times because they want to remain independent, and they feel if you start bringing these things up, that they may lose some control. So I'll be providing you some suggestions to make this conversation a little easier. So timing, of course, the best time to start the conversation is early, when your parents are healthy and active and before a crisis arises. Many people I work with have reached out to us to help them, and it's usually we're reached out to when it's during a crisis. That becomes a little harder on them and the family. And then as we're helping them, we usually find additional problems that take a little more time to resolve, or the resolutions may be limited at that point. So it's best to plan early to have these conversations with them. If you are local, then you have an opportunity to observe your parents often. But observing can be difficult if you live out of town. You can talk to them on the phone or on FaceTime, and everything sounds fine with them, right? But make time for a visit, so that, because going for a visit sometimes can tell a different story. You may see piles of mail or notice difficulties that they're having with writing checks. The holidays are approaching, and so that would be a good time to get in a visit. While none of these observations listed on the screen, the piles of mail, duplicate purchases, may not be red flags on their own, but repeated financial mistakes and changes in financial patterns could be an early sign to problems. So try to come up with a plan in advance. When and where should the conversation take place? Again, this can be hard if you live out of town. As I mentioned, the holidays are coming up, but starting the conversation during the holiday meal may not be ideal. So find a quiet time and don't push for the conversation every day while you're visiting. Who is your father or mother likely to listen to? Would it be all the children or just one particular one? Maybe it's best to include their trusted financial planner or their CPA, attorney, or daily money manager. Or maybe in your family, you have a friend or cousin that your parents know, and they were always the person that seemed to give really good financial advice, and everyone trusted what they said. So those are good people to maybe bring into the conversation with you. Prepare how to start the conversation. So this is a big one. So maybe with one parent, say like, hey, Dad, since you always pay the bills, do you have a plan for how Mom will handle it if you had to go into rehabilitation for a while? And then rehearse it with other family members who know your parents and know what objections they could possibly bring up. So then you can rehearse back and forth what you could possibly say. And finally, what information do you want to acquire or need to know from them? Which I will talk more about the details in that in the organizational strategies. So some tips for the conversation. This is going to be an emotional topic, so don't catch your parents by surprise. Just let them know that you care about them and about their well-being, and that the family respects their independence, and they just want to ensure that their wishes and needs will be met. So regarding the information you need to know and acquire, first, who will manage your parents' health and financial affairs should they become incapacitated? Who do they want? They need to discuss it with all the family members to ensure everyone is available and agrees to helping. And if members cannot help them, then start to work together to gather information about assistance provided, say, by social workers or home health agencies, daily money managers, and your attorneys. Do your parents have estate planning documents in place? The power of attorneys and wills, Jessica Sauer will discuss in detail in her presentation. If they don't have them, would they agree to have them prepared? And if they do have them and their documents are old, ask them if they would be fine with reviewing them again with an attorney, because laws change and laws are different per state. So it's always good to have a review. Also, nowadays, banks they have their own rules with regards to accepting POAs. Sometimes they have their own forms, or they'll take the ones that you have, but they've gotten very particular. We experienced this for a client where Dawn was going to be the power of attorney for them, just to help them with some limited things like accessing their bank account to help them pay for things. And the attorney drafted the power of attorney. The bank didn't accept it. They changed some wording. The bank still didn't accept it. So the attorney ended up having to call the bank and ask them exactly what they wanted to see in the power of attorney, because the back and forth was just getting a little ridiculous. And so each bank is different, as we've experienced. Do your parents have enough money to live comfortably? Of course, this is a very important topic to ask them. Just ask them if they would share that information with you. How do they handle their current living? Do they have long-term care insurance? And if they don't, how do they plan to cover those long-term care costs? Because Medicare does not cover that. And a lot of people think it does, but Medicare does not cover long-term care. So this conversation with your parents may not go as planned the first time, but just be persistent, and you may need to repeat it multiple times with them. So as I mentioned, you would need to also acquire documents. There are 3 good reasons to get financially organized. Number 1, reduce stress and save time. An unexpected transition for a loved one is already stressful, so you don't want to add to that stress with a search for documents. And if you come up empty-handed, then we know that it often requires many very long phone calls to get those items replaced. 2, it saves money, as you will be charged by your bank or attorney to replace or get copies of those documents. And 3, just knowing that your affairs are in order allows you to enjoy your life without worrying about your family having to spend countless hours searching for documents. And for the family members, they will have peace of mind knowing that they can help at a moment's notice. So getting organized ensures there's no delay when you need to get things done timely or make important decisions. So where to start? The American Association of Daily Money Managers provides a list of financial organization tips on their website for peace of mind. 4 main ones to start you organizing are: 1, make note of and safely store important documents. 2, list the financial accounts. 3, passwords, that's a big one. And 4, important contacts. Most of the important documents are ones you need to keep forever, such as the estate documents, IDs and licenses, and the insurance policies, mainly the life insurance and long-term care insurance. For the tax records, keep the last 7 years of tax returns and the supporting documentation. And how do you store them? To store them, it's best to use a fireproof safe or a safe deposit box. Store the originals of the wills and power of attorneys, and ensure your executors and the agent under the power of attorney has an original or a copy. And you can also ask your financial planner and attorney if they can store it. Nowadays, they all have physical or mostly digital vaults where they can store your documents, and they usually ask you if you would like them to store it as well. Keep the original licenses and insurance policies in the safe, like your marriage license, birth certificate, again, the long-term care insurance, and also copies of IDs. This is very important because we know they lose IDs. So having a copy of your state ID, your passport, all of those would definitely be helpful in case it is lost. Tax records and copies of the insurances can be kept in a locked file cabinet. And then most importantly, with these documents, make a note for your family of where to find them, along with the key or the combination to the safe and safe deposit box. Financial accounts. So list the account numbers and how to access all the financial accounts, which checking, savings, investments, credit cards, loan accounts. I know there can be a lot. So it's very important to list those. And for the income sources and bills, for us at Day to Day, we create a bill page checklist for our clients. It's similar to this. So as you can see, it's a spreadsheet, and we separate out the income and the expenses. There's a due date for when the income is, you have direct deposits, or when the bill is due to the payee. There's a list of the payment method, whether it's a manual check or are they paying it through their credit card, and then if it's automatic as well. And then the payment account, whether it's your checking or savings, again, credit card, and then the amount. And this spreadsheet is a good basic tool to use even if you want to start a budget with it. So for most of us now, we can easily have over 50 online accounts. And it's very hard to remember all of them, especially if you don't use them often. So you must have a list of the logins and passwords for someone in the family to effectively help when needed. The most important ones really would be for your computer, cell phone, and tablet, to have that at the top of your list, and then provide the rest of the accounts. And then how can you store those? Look into a secure password management tool. There are so many out there, but find one that you're comfortable with using. For online options, there's Norton and LastPass, or if you're not comfortable with the online, just use manual lists. Update it when you can and lock it in the safe or your locked cabinet. And again, make a note for your family on how to access the online service or the safe so that they can find those passwords. And finally, important contacts. List the details of your important contacts, including the name, phone numbers, and emails. I find that address can be helpful for some, especially if there's many locations, like with some of the financial service companies, the popular ones that we see around. If there is a person who's handling your affairs and they're not a family member, then provide them your next of kin and the agent under the power of attorney. So now your family will be able, to contact your medical and financial professionals with this list that they have. But if the professionals don't know those family members, and they're not listed as a trusted contact, then the doctor or financial advisor or other professional, they will not discuss any confidential information with you. So remember to have your parents contact those professionals ahead of time to add the family member or trusted person to your assigned trusted contacts form. Most of them have some sort of form like that. So finally, to close up, taking the time to get financially organized is worth the effort. It saves everyone time and money. And you will actually be giving your family member an important gift of peace of mind, because they will feel prepared with having the information they need to assist you through a transition. Now I will turn it over to Jessica for her to discuss the legal strategies.
Thank you so much, Mary.
You're welcome.
All right. So tonight I'm going to be talking about the legal aspects of managing life's transitions. And so as I go through this, I'm going to talk both about what you can do proactively, right, to help make sure that those transitions go smoothly for yourself or for your loved ones, but then also how you can recover if plans fail or aren't made. Because as much as we'd like to think we'll always have everything organized, the reality is that sometimes we won't. And so I want to talk about a legal strategy that can help in those situations. So, when you think about estate planning, the thing most people tend to think about are the actual documents, whether you've created the powers of attorney, a will, or a trust. And so today we're going to kind of guide our discussion around the 3 documents that can apply while you're alive. So we'll start with the healthcare power of attorney, go to the financial, and talk about the trust. And then from there, we'll talk about options when these documents aren't effective. So first, a healthcare power of attorney, which is also sometimes known as an advance directive or a living will, is really important because it allows others to be able to make healthcare decisions on your behalf and gives you the power to choose who that person will be. So, to the extent that you want to be in control, to know that someone you really trust will be making these decisions, it's important to get this document in place. The documents also allow you to express your wishes regarding various aspects of your medical care, such as whether or not, there's certain medication you do or do not want to receive, whether or not a do not resuscitate order should be permitted, either immediately or at some point in the future, and your wishes regarding organ donation. But I think that while these aspects can be important to incorporate in your documents, the key thing is making sure that the people who will serve as your agents know what your wishes are and will be able to kind of adapt as things go forward. Sometimes people take the approach that this document should list every contingency, and what you would want the response to be in every case, which can be a little dangerous because the reality is that situations can change. So I think it's more important to really focus on the who would be making your healthcare decisions, so that you know that it's someone whose views are generally in alignment with your wishes and who knows what you want. But there are a number of other questions that we want to ask in looking at our powers of attorney. So the first is, when should this document be put in place? And the answer to that is it should be done as soon as possible. If you do not have one of these in place, you really want to work on getting it done ASAP so that it's there in the event of an emergency. If you're waiting until you need a healthcare power of attorney to create one, it's going to be way too late. So, you want to be proactive in getting this done as soon as you can, even if it's not a particularly fun thing to think about. But other questions that you should definitely consider as part of the process is, when should others be able to speak with your doctors? Do you want to take a position that they should only be able to talk to your doctors when you absolutely are incapable of making decisions for yourself and your doctor is the one making that determination? Or would you rather allow your spouse or trusted children or a trusted friend to be able to speak to your doctor all along, so that they can really serve as a support to essentially ensure that your needs are being taken care of as you age? Sometimes it can be really helpful to have someone sit in on those conversations with doctors when you're getting a lot of details thrown at you. The doctor might be discussing multiple options for different types of medication, And so, allowing someone else to be able to be in the loop with your medical team can be a really great way to make sure that when you do need help, there's someone who's already somewhat knowledgeable of your needs and can step in to assist you with that. Other things to consider, which can also be in your document itself, is where do you want to be cared for as you age? Are you strongly opposed to receiving care in a nursing home? Well, if so, you can definitely note that wish and express it in your document. But then you also need to make sure that you're making plans for yourself beyond the documents to make sure that that's a sustainable plan. And then another thing to consider is, hey, making medical decisions for someone can be a really big responsibility and very difficult. So is there anyone who can support your agents in doing that? So essentially, is there a palliative care team you might trust for assistance in doing that? Is there a professional you might want to pull in so that there is a professional advocate there with them, walking alongside them through some of these difficult choices? And another one that's probably the most common one is hospice care. Understanding that, hospice care can deliver support whenever there's a possibility, essentially, that you might pass away within 6 months. So you don't necessarily have to be, actively physically dying in the sense that, you'll pass away in a few days in order for that team to come around you and really help your loved ones through that time of transition. A lot of people find that to be a very positive experience. Okay, so in terms of practical tips, yes, as Mary stated, you want to make sure your agents and your doctors have copies of your advance directive that you've created. You want to make sure they know where to find the originals when needed, and really just help facilitate connection where you can. And likewise, at some point, you probably want to make sure your agents are aware of what medication you're taking and, introduce them to your doctors so that when they need to have some of those difficult conversations, they'll already know each other, and hopefully that'll make that a little bit easier. You also want to make sure that you're setting yourself up for success with your housing situation. And, I always talk with my clients about how important it is to make sure that wherever they're living as they age is going to be able to set them up for success. So, you might want to start considering things like handicapped accessibility. And then also this tip came along from Darla, who did our introductions today. Thank you, Darla. But one thing that she sees in her role at Your Tasks Are Time is that, sometimes as clients get older, they really need help cleaning out the clutter in their homes. And I think it's particularly important, and Darla has said as much, that you want to make sure you can establish wide walkways through your home so that essentially, you have an area where you can navigate if a medical emergency arises. And Darla also highly recommends to be very wary of throw rugs, which can cause a lot of problems and potential accidents. I think that when you're doing your state documents, it's also a good time to consider independent living possibilities and other continuing care facilities, because when you get into those situations early, you can often do it more cost effectively, and you can have the peace of mind of knowing where you would receive care. It also gives you the advantage of potentially being able to bring help into that facility, as opposed to having to leave your home and then, go into assisted living directly or nursing care. Sometimes when you're already in independent living, it's possible to bring in help to that area so that you maintain more independence as you age. And it's also really important to make connections now with people who can help guide you through those decisions later. So shifting gears to talk about the financial power of attorney, essentially that document would allow you to appoint someone to make decisions regarding your business, legal, and financial affairs. This includes pretty much everything from A to Z, including buying and selling property. And the reason why you want to include these powers is so that your agent can actually have them and make sure that they can do these things. In this document, you can specify whether your money should be used for you alone or whether it can be used to benefit anybody else or a charity while you're still alive. And you can put the terms on there about how they can be benefited and when. But there really are two essential questions that you need to face when thinking about making a financial power of attorney. And the first is, who should you choose as your agents? And obviously that's a big question, for all the other documents as well. So I'm going to try to give you some guiding principles about who to choose. And then when should your financial power of attorney be effective? So let's look at those now. So, sometimes it can feel a little overwhelming to decide who should serve as your agent, especially if you're a single person. Many times if you're married, it might be a clear decision to put your spouse in. But if you're single or your spouse has passed away, or for whatever reason, you feel that they're not capable of the task at this point, you want to take a look at, others that might be an appropriate fit. Oftentimes that is a child, a sibling, someone that you're very close to and really trust. And I think that, the decision of who to choose is personal to everyone, but at the end of the day, it's very important that you feel confident that you know that they will do what they say they will do, and have that element of honesty, that they are not lazy, that you know that they will get done what needs to get done, and so that you could be taken care of, and your assets will be there for you as you age. And finally, someone who has good communication skills and is able and willing to make themselves available. Someone could be a financial wizard, but if you can never get them on the phone, that really can be a problem in terms of choosing them as your financial power of attorney. So sometimes it's not necessarily, choosing the person who has the deepest knowledge of the markets and investment. Certainly that's a factor to consider. But at the end of the day, the reality is that your agent can hire professionals to help them with those specific decisions. But you really want someone guiding the ship who you can really trust, that will do the work, and that will share about that with your other potential beneficiaries, so that there aren't hard feelings within the family or amongst whoever you intend to benefit after you pass away. So when should this document be effective? Well, there are really two primary approaches. One is allowing your agent to do whatever you could do for yourself as soon as you sign it. So essentially having it be effective immediately. The second option is allowing the document to be effective when two doctors indicate that you are incapacitated. So some clients prefer this approach because they'll say, look, I really only want this document to be used if I'm essentially in a coma, and it's very clear that I cannot make decisions for myself. And, I respect that position. But at the same time, I think that particularly as we're talking in the context of preparing for life's transitions, we have to recognize the possibility that before we're completely incapacitated and we have others, who can clearly state, hey, this person can't make their own decisions, there may be a bit of a gray area where capacity is diminishing and maybe forgetfulness is kicking in. I'm familiar with a situation where someone's mother was suffering from dementia and had a relative who kept coming to her for money. And she forgot that she had been giving him money and continued to give him money and give him money. And because the financial power of attorney, wasn't saying that, look, her son could take action immediately to essentially move the funds to another account so that, that couldn't happen anymore, where she would forget what had happened and just keep, giving money to this other relative. He was in the position of having to take a more extreme measure to be able to intervene to help his mom. And unfortunately, by the time, he had others sign off on it, a lot of damage had been done to her affairs. So, to the extent, again, that you're choosing people that are honest, that you trust, in general, you might want to consider having this document be effective as soon as you sign it. And if for some reason you're not comfortable, right, with relying on one person to have that much power, because it is a lot of power, you always have the option of having multiple agents. So for example, in situations where maybe it's a second marriage situation, you might want to have your spouse on as well as one of your children from a previous relationship, so that essentially they have to agree on what gets done in order for anything to happen. So, that's an extreme example. And if they don't get along, there could be reasons why maybe that's not the best scenario. But at the end of the day, if you know that you have two people on there that you would trust independently, and you set your document up so that they have to work together to take action, that can give clients a lot of peace of mind while still making it relatively easy for their agents to take action. So, when deciding when it should be effective, you want to consider how much aggravation, right, will you be putting your agent through, who should serve. And again, to the extent that you're able to rely on them, that can definitely be a factor. If you have multiple agents, that can help. And then the final thing, well, not final, because there's always an unlimited number of factors to consider, but one of the main other things to consider is, how does this financial power of attorney fit in with your overall estate plan? So while we're not talking about wills per se, will whoever is making the decisions while you're alive be able to kind of have a unity of interests with the person who will be making those decisions after you pass away? So basically, here talking about life transitions, it's important to recognize that trust planning can have benefits during your lifetime and not just after you pass away. So a trust is an agreement you create for the management and distribution of your property. When you create a trust, you get a fancy title. You're known as the grantor. And when you are administering the trust for someone else, you're known as the trustee. So there are many different types of trusts, and I won't waste your time really explaining all of them in detail. If you're interested in learning more about trusts, there's a previous presentation you can scroll through to get all the details. But in terms of a big picture scenario, most of the time, to the extent that people want a trustee to be involved to help them with lifetime issues, we would do that through a revocable living trust. So that's a type of trust that you can change while you're still alive. So like a Ziploc bag, you can open it up to put assets in, take assets out. You retain control over that trust while you're still alive. And so, in terms of lifetime benefits, the main one is really that when you move assets to the trust is now the owner of those assets. So whoever is serving and appointed as trustee can essentially move where those assets are located and make all decisions related to trust assets. That starts to be really helpful when you have multiple properties to manage, properties in multiple states, and anytime that you really want to make things easier for your agents. So one of the times you might want to do that is if you're considering hiring a professional trust company to help manage your assets. Maybe for whatever reason, you don't have those trusted people in your life, that you feel comfortable relying on to manage your financial affairs, and you want someone independent and neutral to be in that role. When that happens, many times those companies will require your assets to be in a revocable trust in order for them to manage them. So that's definitely probably one of the very many strong reasons people consider when creating a revocable trust. It can also make transitions easier in the sense that just like you could have a financial power of attorney effective immediately, you can have a co-trustee on your trust. So you could start off as the initial trustee yourself, with rules about when the successor trustee could step up either as a co-trustee or as a sole trustee. Or, if you really want to keep things simple in certain ways, you can start out with a co-trustee so that after you create the trust, you know who else can manage the assets and assist you with them. There are a couple of perks of these revocable living trusts and just things to be aware of. Notably that this type of trust doesn't need its own separate tax return. You would still file, your taxes in your own name for any assets owned by the trust. And, if it's properly structured, you can keep the tax benefits of having property in your own name. This is also a very direct way to bypass the ability of a court to appoint someone else to control these assets, because you, as the creator or grantor of the trust, control who the trustee will be, and you can name successors as well. So for those types of trusts to be effective, it's very important to change legal title. And again, part of the longer presentation, but the 30-second informational piece that you need to know about this is that essentially you would shift assets from being in your own name to being in your name as the trustee of whatever you decide to name your trust. So for me, Jessica Sauer, I would move my assets into the Sauer Living Trust, and just like the example noted on the slide. And it's always recommended to keep proof of new ownership and beneficiary designations. And as Mary indicated, to keep things really organized. Having a daily money manager like Dawn and Mary is so important as people age, to help them stay on top of their bills and getting things done. And, they're able to assist people, whether they're serving as the financial power of attorney, as the trustee, or, even just seeking out help individually. So can be a great tool to help keep you organized. And then, as you create this trust, you want to make sure you get anything linked to your personal accounts taken out of there before you shut those accounts down. So what if plans fail? What if you appoint someone under power of attorney, but they end up passing away and you haven't named a successor, which, by the way, I always recommend you name at least 2 successors. And ideally someone from a younger generation as well. But what if you haven't, or what if something happens to all of them, or none of them are willing to serve? Or what if there's an extreme conflict in the family and someone feels like you're being taken advantage of by whoever you put in as your financial power of attorney or healthcare power of attorney? In these types of situations, the remedy that's provided by law is known as guardianship. And it can be guardianship of the person, which would mean that they would be responsible for health and living decisions on your behalf, financial affairs, which would be guardian of the estate, or the same person could potentially serve in both roles, or potentially you could have different people in both roles. The guardianship can also be limited or restricted so that it's really there for what you really need it to be, and no more expansive than necessary. Of course, proving what actually is needed and what's excessive can definitely be a sticky and difficult situation. But the general trend in the courts is to restrict that as much as possible so that people are taking action to the extent needed, but otherwise people are able to maintain autonomy to the extent that that can be safely done. But in proving a guardianship action, the keystone for Pennsylvania residents of the Keystone State is incapacity. And the burden of proof is clear and convincing evidence. So what does it mean to be incapacitated? Well, under Pennsylvania law, essentially, if you're an adult whose ability to receive and evaluate information effectively and communicate decisions in any way is impaired to such a significant extent that he is partially or totally unable to manage his financial resources or to meet essential requirements for his physical health and safety, that is an incapacitated person. So, the keys are communication and the ability to receive and evaluate information. So when those skills are gone, that's where we're really looking at alternatives to the person acting alone. So the first and most important alternative is those powers of attorney. So if you've taken the time to create those documents, for the most part, those documents will serve to protect you in lieu of guardianships. And courts do consider the applicability of those documents when making decisions about whether or not to appoint someone as guardian. Because to the extent that we have trustworthy people making decisions for you, there's not really a need for the state to be involved beyond that. But that being said, again, there are situations where maybe for whatever reason that's not appropriate. So essentially, when we're in that situation, right, where someone is thinking, there's something off here, or the document just isn't there, the question is, what do they have to prove? So essentially, to prove that incapacity, they need to make sure that they're presenting testimony, usually done by a doctor or psychologist, to basically show various different facts, but really talking about their condition, their skills, the types of help they need, and any less restrictive alternatives. So really delivering a comprehensive report to the court about how that alleged incapacitated person is doing and what they need help with. So the way to initiate a guardianship proceeding is to file a petition in the Court of Common Pleas. And the awkward thing about this is you have to make sure that the petition is served on the alleged incapacitated person. So, if someone is going to seek guardianship over you, they have an obligation to tell you that they're going to do that. But it's important because really, the law wants to make sure that nobody is in the dark and no one's getting rights over another person without them having an opportunity to object and to know what's going on. So you have to make sure that the person gets a copy of the petition, and then you have to include a notice in large letters that essentially explains when and where it will take place, and then further explains what's going on and how they, what they can do, and the fact that they can request that the court appoint them an attorney. So, it's unlike New Jersey where it's automatic that a guardian be appointed. In Pennsylvania, it's up to the discretion of the judge. But that's really important because, sometimes people might feel intimidated to be in that court setting and arguing for themselves, but they want to make sure that there's someone doing that for them. So the law does provide a mechanism for that. And you also can't file for guardianship behind the back of other interested parties. So behind the back of someone's spouse or essentially their kids. So, again, we talked about what needs to be proven, and it's a pretty high burden, right? To understand what's going on with the person. So once that initial case is made, the question becomes, well, who can be appointed as the guardian? And, the short answer is pretty much anybody could be appointed. But the more essential question is, well, who has priority of appointment? So first, to the extent that you've created powers of attorney and you've named a healthcare agent, that person would have first order of priority in terms of being appointed as the guardian of your person or person responsible for making information or decisions about your healthcare arrangements or where you live. Similarly, if it's a situation where someone is seeking to become your financial guardian, They would look at your financial power of attorney to see if you've appointed people there. They would have first order of preference. Beyond that, it would be your spouse, assuming, of course, that you are still together. If there's a separation, the court might say, nope, we don't want that person to serve for very obvious reasons. Beyond that, it could be an adult child. It could be your parent. It could be someone named by your parent, assuming that you're not married. It could be your sibling or a grandchild, assuming they're adults, other family members. And then, one of the last steps before we essentially appoint someone chosen at random by the court or brought forward by your facility would be someone who really knows your values and preferences. So essentially a good friend, to be able to be in that position to assist you. But if there's no one available, the court can appoint anyone they feel is appropriate and qualified. There are some limitations on these where essentially we don't want to appoint someone who has a really blatant conflict of interest. And there are some other factors that the court will consider. For example, if your chosen agent is taking money from your accounts through your financial power of attorney, obviously information about that should be presented by whoever is seeking to be appointed as guardian instead, so that the court can weigh, what's going on and assess whether those are lawful expenditures or reimbursements, or whether, it's a problematic thing indicative of bad character, and essentially that person should no longer serve. When someone is acting as guardian, they need to act as a fiduciary, so they cannot benefit themselves. So unlike under a power of attorney, if you clarify, yeah, I'm fine with my agent making gifts to my kids and grandkids, if we're in the guardianship arena, those abilities essentially end. And your agent or guardian can only make decisions and take actions that are for your benefit alone. And they also have an ongoing obligation to avoid situations where a conflict of interest might arise, because we don't want them essentially setting themselves up to benefit themselves over other siblings or family members. And there's significant reporting requirements that go along with serving as the guardian. So, when you're serving under a financial power of attorney, it's always a very good idea to keep detailed records and receipts. But in guardianship, it goes one step further, where essentially a statement about all the person's assets and income need to be disclosed to the state. And there are numerous times there it needs to be disclosed. And, information also has to be disclosed about how all that money is being sent and what exactly you're doing to assist the person. And that's on the financial side of things. On the healthcare side of things, there are other obligations, talking about how the person is doing, whether guardianship is still needed, and a whole variety of other information. But the reality is that you're giving multiple reports within 90 days of being appointed. That's your first one. And then you do it annually every year thereafter. But even when the person dies, you're still not completely done, because you owe the court a final report. And essentially, if the person moves to another state and a guardian is appointed there, you would owe an accounting or final accounting to, the court before the transfer. So, when thinking about life's transitions, it's really good to consider what your goals are. Do you want to make things easy for your family? Do you want to make sure that certain people are in charge of certain aspects of your care as you age? If so, it's very important to consider making an estate plan that incorporates those aspects. So talk about your wishes with the people you trust, try to get the general idea of what you want, and then meet with an attorney. One of the things I do when I chat with people is I help reality test their ideas a little bit. Sometimes clients come in and they'll have a detailed list of everything they want, and that's great. Sometimes by the time we're done talking, they still have those same wishes. But sometimes, when questions are asked about, hey, how will these people work together? What are the concerns about this person? It broadens the conversation to consider factors that maybe they didn't think about at the outset. So, in making any decision, it's always good to have good counsel and to really reality test those solutions. So, if you don't feel, you certainly can do it on your own, but at a certain point, I do think it's helpful to meet with an attorney to discuss your estate plan and to see how you can take care of the legal side of things to help make it a smoother transition. Thank you so much for your time today.
Thank you so much, Mary and Jessica, for this informative and educational presentation. This is something that we all need to plan for in our lives, and it's helpful to know and understand what we need to be prepared. And by failing to consult a professional early on, we can miss out on making our wishes known. So before we close, I'm going to check to see if we have any questions in the chat. So there is one question. Mary, you had given a list of documents to keep permanently. Is there a place where they can, I mean, I know people could have taken notes, but is there a place they can get that list?
We can probably put it up on our website, the Senior Services Network website, so we can provide that, or maybe get it out to the attendees somehow.
And then the same for you, Jessica. Is there like a list of like certain documents or things that would make it easy, some kind of a go-to list?
Yeah, I can do you one better. Essentially, anybody who reaches out to me individually, I'd be happy to set them up with an intake sheet where we can really get into the details of what their agents would need to know. That's how I start my consultations with clients, because, you know, not only does it help from the planning perspective, but it's really great for their relatives to have that information after they pass away.
All right. Well, thank you. Thank you. It's very helpful.
And my email address, if anybody wants it, is jessica@sauerfirm.com.
All right. Thank you. So before we close, I would like to highlight our upcoming presentations. Our webinar topic is for November is Wednesday, November 16th at 6:30 via Zoom. Our topic is holding a productive family meeting. The presenters for that topic are Dave Emery from Planning Capital Management and Kim Sager of Bridges of Warwick. Then our December webinar is December 14th at 6:30 on Zoom. And that topic is what to do with mom's pet. And those presenters are Diane McGee, Esquire, from Graham, Bien and Thatcher, and Linda Reeder from Bucks County SPCA. We do have a very short 3-question survey that we would very much appreciate you completing. The survey will help us plan for future topics and keep us on track for creating content that you want and need. And finally, we are happy to answer any questions that you have about what we do, and we invite you to check out our website. If you have any questions about this evening's presentations, please feel free to reach out directly to our speakers. Until next time, we look forward to hearing from you and hope you and your family and your loved ones will join us each month. Thank you.